When it comes to fundamental rights and freedoms, common law rights, there seems to be a lot of misconceptions that are going on the internet. I hope this video will help to clear up the misconceptions here in Canada. When we look at rights and freedoms, we look at the designations or the terms used to express or explain the rights and freedoms. We find the terms natural right. Now, this is a right that exists apart from the government. It is not a right that the government created. It is a right that the government must respect, but the government did not create it. An inalienable right means it's a right that cannot be surrendered or transferred. An absolute right means a right that belongs to every human being. Every human being possesses this right. Some people will say that these rights find their expression or are transferred into common law, and they'll call them common law rights. However, when you look into Canadian domestic law and the court judgments and jurisprudence, you find just the opposite is being declared by the courts. The courts are saying that all these rights now, natural right, inalienable right, and absolute rights, are actually what we call, or what are titled, fundamental rights and freedoms. And these fundamental rights and freedoms, again, were not created by the government, and every single human being possesses these fundamental rights and freedoms. You and I and everyone else possess these fundamental rights and freedoms. And therefore, we can exercise these rights and freedoms. When we're looking at jurisprudence, there is a court case called M.A. versus Ryan. It's from 1997, and it's a Supreme Court case. And it states, the Supreme Court has made it clear that the common law must develop in accordance with the Charter values. A trespass in common law equals an infringement or denial of a fundamental right or freedom. So we are seeing in the Supreme Court case of Canada, M.A. versus Ryan, that it states common law must develop in accordance with the Charter, the Constitution of Canada 1982. And it states that a trespass now in common law equals an infringement or denial of a fundamental right and freedom that is found in the Charter. So in order for you to declare a trespass under common law, you have to be able to prove and show that there was an infringement or a denial of one of your constitutionally protected rights, one of the rights and freedoms guaranteed in the Charter of Rights and Freedoms, and subsequently in the covenants. Because we know that the Charter is an expression of the covenants, it's an expression of international law. So now, once again, if you walk into court and say, I've been trespassed against in common law, and you use any other evidence to back up your claim, or draw your rights from any other document except the Charter, then you're not producing the evidence that you need to bring before the court in order to prove an infringement of your right and freedoms. Because the courts are saying that in order for you to prove an infringement of your rights and freedoms, a denial of them, you must prove that there was a trespass against one of your Charter rights and freedoms. We're looking at a court case right here. It's titled R versus Haynes, and this deals with directly fundamental rights and freedoms here in Canada. And it states, prior to the Charter's advent, the Charter of Rights and Freedoms, the Constitution of Canada 1982, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state. Beyond making representations to the executive or administrative arms of the government, or petitioning and lobbying Parliament or legislators for changes in the law, linked, as they were, to concepts of parliamentary supremacy and sovereignty, there were no means at the disposal of individuals to muster court challenges aimed at invalidating legislative, executive, or administrative acts. So the court is saying here that prior to the advent of the Charter, an individual did not have much power in order to have his rights or freedoms respected. Now, it goes on to say, apart from these exceptions, The individual's means of challenging incursions on fundamental rights were extrajudicial and of a precatory nature, that were neither effective nor potent. Respect for the rule of law, upon which, as W. Ivor Jennings in his text entitled The Law and the Constitution points out at page 42, that it hinges the existence of public order, mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. So, prior to the Constitution Act of Canada 1982 being implemented, public law was the most important fact or matter, and an individual was expected to submit to public law, to enactments and regulations, even if these enactments and regulations infringed upon their natural rights, their inalienable rights, their absolute rights. This is what law was back in the day. Continuing on in R versus Haynes. Now, a primary purpose of the Charter was to change this relationship of the individual with the state and its laws by endowing individuals with an effective means of challenging acts of the state in courts on the ground of violation. Looking at another court judgment, a reference from Can Lee, the Criminal Code. You see on page 42 of the judgment it states the following: it is important to note that the onus or responsibility is on the person bringing the challenge to demonstrate not only the restriction of the rights, but also that the state has not abided by the principles of fundamental justice. Now, as we saw, prior to the advent of the Charter, the Constitution of Canada 1982, an individual did not have much protection against an infringement of their common law rights. There are many that teach and say, well, if they infringe upon your common law rights, do such and such things. Make a commercial judgment against them. Produce an administrative judgment against them. That's what they're teaching now on the internet. And the courts are saying that even prior to the advent of the Charter, even if you try administrative judgments and so forth, it didn't work for the individual. The individual wasn't empowered. He didn't have any rights backing him up in order to be able to exercise his fundamental rights and freedoms. But since the advent of the Charter now, an individual has a way to protect. He has been empowered. He can go before the courts and say, I have fundamental rights and freedoms. I have inalienable natural rights. And this enactment here is seeking to remove my right and freedom. And this is against my fundamental rights and freedoms. This power has been returned to the individual. Now, when we're looking further into court, and I didn't share you this judgment, when you look further into court in R versus Haight, I've shared this in other videos, it says that the courts presume, listen to those words, they presume that all domestic law conforms to international law. All domestic law basically respects fundamental rights and freedoms. Now, the onus or the responsibility is on the individual to demonstrate to the court that the enactment that they're trying to make me follow, it does not conform to international law. It disrespects my fundamental rights and freedoms. And the secondary proof that you must bring before the court is to show them that by them denying your right, by the state party denying you your right, it is against the principle of fundamental justice. We find the principles of fundamental justice expressed in the covenant itself. So those are the two, if you will say, obligations that you have before the court. The onus is on you to say that my right or freedom, my fundamental right or freedom has been infringed, and this infringement or denial of it is against the fundamental principle of justice. It's against what we find in the Charter. It's against what we find in the covenants. So we have no other choice, as you can clearly see. For us to seek the administration of justice, we need to use the Constitution Act of Canada 1982. Why? Because it is a direct expression of fundamental rights and freedoms, i.e. common law. Some people are saying, well, where's the common law in Canada? And there's common law in Canada. Now you know. You won't see common law when you read the Charter of Rights and Freedoms if you don't understand what common law is. But if you understand what common law gave to a man, if you understand the rights and freedoms that common law produced for a man, when you read the Constitution Act of Canada 1982, you see the expression of common law there. For example, a human being, right? In common law, he has the right to liberty, to freedom. That's a big claim that everyone is saying. A man under common law can be free. Well, when you go into the Constitution Act of Canada 1982, Article 7, I shared with you on another video about this, the designation there, everyone is strictly a human being, or man or a woman. And in there it says that man or a woman has the right to liberty. Everyone has the right to life, liberty, and the security of the person. So the common law right to liberty has been expressed through your fundamental rights and freedoms in the Charter of Rights and Freedoms, the Constitution Act of Canada 1982. Now if you go at the courts, if you go at this in any other way, making claims, administrative claims, commercial liens and all this, you're going to fail. The road has already been laid down for all of us, individuals who understand what's transpiring here in Canada. In fact, there was a judge from the Supreme Court of Canada, and this will be the last one that I share with you right now, that explained to us what it is that we're seeking when an individual goes before the court in order to have his fundamental rights and freedoms respected. We're seeking the administration of justice. When you use that term, administration of justice, that's what you mean. You mean that someone stole my fundamental right and freedom. Someone denied me the right to exercise my fundamental right and freedom. And now I'm seeking the administration of justice. Why? Because no one has the right to do that to me. Why? Because they're inalienable. They can never be surrendered nor transferred. They're absolute. They belong to me. And they're natural. They were created not by the government. They exist for me. And when the government tries to steal them by not allowing you to exercise your fundamental rights and freedoms, it's through the Constitution Act that you go before the court and you say, here's the right I've been granted, here's the restriction of the right that the state party is doing against me, and I would like a remedy. So don't let anybody tell you otherwise, because you're going to come across some videos on the internet, and I know because I've come across them, and they're going to tell you that, you know, in order for you to get your freedom here in Canada, you need to do an administrative process, an administrative judgment, or a commercial lien against them. It's not it at all. As you begin to study and understand more and more about your rights and freedoms, guess what? You, the individual, the law has empowered you to go before the court and have your administration of justice dealt with. But you need to know what's going on before you can ever go there.